Hello everyone, welcome back to another episode of Courts Today by Live Law, your one-step destination for the latest and fastest legal updates. I am your host Urvashi Chauhan, bringing you day-to-day happenings, landmark judgments, crucial rulings and expert insights into the world of law. Let us start with the headlines and a brief overview of the top stories, and then we will dive into full details and in-depth coverage of each update. The Bombay High Court has declined to order certification of the film Emergency. It cited judicial propriety amidst ongoing proceedings before the Madhya Pradesh High Court. The Supreme Court has today put on hold for 1 week enforcement of its order on marking advocate presence in the Supreme Court. The Apex Court has reserved judgment on the issue whether an accused under PMLA is entitled to documents which the prosecution is not relying upon in trial or not. The Supreme Court questioning Uttarakhand Chief Minister on Rajaji National Park Director appointment has said that we are in feudal era and public heads must show accountability for their decisions. The Supreme Court has today stayed Gujarat High Court order refusing apology published by Times of India for wrong reporting. The Delhi High Court has upheld dismissal of a government employee for 20-month absence from duty and for making scandalous allegations against the employer. The Punjab and Haryana High Court has upheld dismissal order of a cop during 1980s, saying that terrorism in Punjab was at its peak at that time and witnesses would not come forward. The Bombay High Court today ordered Central Board of Film Certification to decide by 18th September the representations made by Jabalpur Sikh Sangat or any other group or individual objecting to release of the controversial film Emergency. A division bench of Justice B. Kolabawala and Firdos Pooniwala opined that the board has no powers to get into the issue of deciding representations or any unrest to the release of the film. However, it refused to pass any direction to the board to immediately issue the certification. The bench was hearing a plea filed by Zee Studios, the co-producer of the film Emergency, which stars Kangana Ranaut, the sitting member of parliament from Mandi in Himachal Pradesh. The plea states that on 29th August, the board sent an email to Manikarnika Films, which is owned by Ranaut, informing them that their film had been successfully certified. However, when the production team went to collect the certificate, they were denied the same. Countering these contentions, the counsel for the board argued that the email on which the makers have relied was system-generated one and that a certificate is only issued after it is signed by the chairman of the board. But the bench stated that once the board sends emails confirming the film's certification, it is hard to accept the argument that the certificate has not been issued just because it was not signed by the chairperson. The bench pointed to the order passed by Madhya Pradesh High Court yesterday, which had already ordered the board to decide the representations of the Jabalpur Sikh Sangat before certifying the film. The court has therefore asked the board to decide the representations by 18th September. In the next update, the Supreme Court today put on hold its previous order that only presence of advocates who are either present or assisting in court proceedings will be marked. The bench had issued the direction after noting the practice of marking presence of advocates who were neither physically nor virtually present during court proceedings. The order also stated that presence of advocates who are not present in court, even if associated with an advocate's office, should not be marked. Supreme Court Bar Association President Kapil Sibal today mentioned the matter before the bench and sought time to streamline the issue. After Sibal's mentioning, the bench comprising Justice J.K. Maheshwari and Justice Rajesh Bindal said that the directions will not be given effect for 1 week. The Supreme Court today expressed displeasure at decision of the Uttarakhand Chief Minister to appoint Indian Forest Service officer Rahul as director of Rajaji Tiger Reserve, overlooking the pending disciplinary proceedings and adverse reports against him. The court was hearing the issue of illegal constructions and tree felling at the Jim Corbett National Park. During the hearing, the court was informed that while departmental proceedings were pending against the IFS officer, he was appointed to the post of director at Rajaji National Park. The bench, led by Justice B.R. Gawai and comprising Justices Prashant Kumar Mishra and K.V. Vishwanathan, noted that the Central Empowered Committee had objected to posting of the Chief Conservator of Forest, Mr. Rahul, to Rajaji National Park from Jim Corbett, yet the Chief Minister proceeded to allow the posting despite multiple recommendations by the Forest Ministry, Chief Secretary and CEC against it. However, the court recorded that as of yesterday, the state of Uttarakhand withdrew the earlier posting of the IFS officer and that he was now posted as Chief Conservator of Forest, IT Department elsewhere. Justice Gawai also observed that there is something like public trust doctrine in this country. The heads of the public offices cannot do whatever they want. He expressed that we are not in the feudal era and public heads must show accountability for their decisions. In another important update from the Supreme Court, it has today reserved judgment on an important issue, that is entitlement of accused under PMLA to get seized documents that the prosecution does not rely on before commencement of trial. This issue emerged in an appeal against a Delhi High Court judgment which held that prosecution is not obligated to provide such documents at the pre-trial stage. The appellants have contended that PMLA accused is entitled to get both relied upon and unrelied upon documents at the earliest stage. The ED has contended that the accused has the right to get the unrelied on documents only after framing of charges, and till the trial begins, the accused is only entitled to a list of the documents. Additional Solicitor General S.V. Raju, appearing for the respondent, that is the Enforcement Directorate, contended that handing over documents can impede the investigation. As though the investigation concerning a particular accused may be complete, it may still be ongoing related to other accused, and the concerned document may be relevant for that investigation. To this, Justice Oak pointed out that if an accused needs documents to apply for bail or demonstrate a plausible defense, there should be no restriction on their access. Senior Advocate Gopal Sankara Narayan, appearing for the appellant, stressed that unlike in ordinary criminal cases, the accused in PMLA cases has the onus to adduce evidence in every stage such as bail, etc., and thus should get access to the documents at an early stage before commencement of trial. During the hearing today, the bench of Justices Abhay S. Oak, Ehsanuddin Amanullah and A.G. Masi questioned whether withholding clinching documents in favor of an accused would violate the right under Article 21 of the Constitution. Justice Oak also said that the bench was considering whether it should lay down the law in this issue or refer it to a larger bench. The Apex Court has today stayed order of the Gujarat High Court, which directed Times of India newspaper to publish a fresh apology for wrong reporting of a court hearing. The Gujarat High Court, led by Chief Justice Sunita Agarwal, had issued notices to Times of India, the Indian Express and Divya Bhaskar for misreporting the court's observations during the hearing, which gave the false impression that the court's comments were final views. Although the newspapers later published apologies, the court found that these apologies were unsatisfactory and that they lacked clarity about what they were apologizing for. The court criticized the newspapers for not specifying that the apology was for their incorrect reporting, deeming the apologies as superficial and insufficiently remorseful. On 2nd September, the High Court had granted them 3 more days to issue a clearer public apology on their front pages. Against this order, the Supreme Court bench of Justices B.R. Gawai, Prashant Kumar Mishra and K.V. Vishwanathan was today hearing a petition filed by Bennett Coleman and Co. Limited, the company which owns the publishers, The Times of India. While granting leave on petition to the Registrar General of the High Court, the bench directed that the impugned order will remain stayed. It, however, clarified that the main proceedings in the High Court relating to amendments to the Gujarat Secondary and Higher Secondary Education Act will continue. The Delhi High Court has upheld dismissal of an income tax official, Vaishnav Bandhu Gupta, who was terminated for a 20-month unauthorized absence from duty and for making false and scandalous allegations against his employer. A division bench comprising Justice Suresh Kumar Kaith and Justice Girish Katpalia ruled that the dismissal was justified. The court found that the officials' acts of misconduct were severe enough to warrant dismissal and that no lesser punishment would have been appropriate. This decision came in response to a plea challenging the Central Administrative Tribunal Delhi's order, which had upheld the dismissal. The court referenced various Supreme Court judgments affirming that scope of judicial review in disciplinary cases is limited to examining whether the punishment is proportionate to the misconduct. The High Court emphasized that the penalty imposed by the disciplinary authority did not shock the conscience of the court, asserting that even under full judicial review, no lesser punishment would be proportionate to the misconduct. And lastly, the Punjab and Haryana High Court has held that it was just and fair to dismiss a constable allegedly having links with militants in the year 1988 without conducting an inquiry because terrorism was at its peak in Punjab and that time no witness would have come forward. In this case, Constable Dalbir Singh, who was stationed in Jalandhar Cant, was dismissed from service without any inquiry, allegedly due to suspected links with militants in Punjab. He filed a lawsuit seeking a declaration that no charge sheet was issued nor any inquiry conducted against him before his dismissal. The trial court had ruled in his favor, decreeing that the dismissal order was inappropriate. The present plea was filed in 1992 and was a second appeal. The High Court has now set aside the order of the trial court. Justice Namit Kumar observed that there was sufficient material with the department that Singh was involved in unlawful activities and had links with extremists. Therefore, it was not reasonably practicable to hold inquiry against him, nor any witness could be associated in the inquiry. Therefore, the order of his dismissal was rightly passed by dispensing with the departmental inquiry. If you wish to know more details about the cases that I mentioned here, you can visit our website at www.livelaw.in. Stay ahead with quick legal updates only on Live Law. Do not forget to like, share and subscribe and support us. You can also support us by donating through the thanks button at the bottom of our videos or consider becoming a member at just 89 rupees per month.